Delaney Loyd, motion for early term. Can I invite her up? Sure. Thank you. Ms. Loyd, come on, please.
All right, bring it down a little bit, folks. Bring it down.
Okay. All right, good motion. Now, if you need it, bring it up, because we can use it. Thank you, Your Honor. As we stand before this honorable court, Delaney Loyd, vying through my motion and the opportunity to stand before this court, is asking for early termination supervision. Judge, the court will recall that we've been here previous to this occasion, and her points are extraordinarily de minimis. She has no prior record whatsoever, no misdemeanors, no felonies, nothing on her record other than this case. And in this case, she actually went to trial. She was before Judge Lemonitis, and she was found guilty. The judge gave her 1 year of county jail, followed by community control, followed by probation. And she completed the jail time, she completed the community control, and over the course of the entire 5-year period, because the jail was a condition of probation, her points were so de minimis, the judge made it a condition of her probation, and so she served now more than 2.5 years of the 5-year supervision requirement, which, like I said, was community control, jail, and probation. She was given 1,000 hours of community service. Up to this point, which I'd like to be able to argue that 1,000 is extraordinary. I've never heard of 1,000 in my 34 years, especially based upon the type of crime that she was charged with. She's completed to date 658 hours and 25. More than half of her community service hours. I'd be asking that the court terminate the rest of it. She has abided by not just all of the items that she's required to, paying the cost of supervision, any and all other court costs associated with the judgment and sentence of the court, but she's done everything that has been asked of her up until today's date as well. And Judge, she is a mother, she's a wife, she's an individual who works in our community to better our community, doing a bunch of things without having to be asked to. And she also handles some news things under Better Business, is that correct? No, Better, what is his name? Yeah, Dwarf's Business News, as well as other news organizations she aids and helps. And Judge, I'm asking this honorable court to get a grant for the early termination.
The state would be objecting, Your Honor. The victim wrote a letter that he would like to read this. I'm just going to read it for you. We would be objecting based on the nature of the charge, based on what she did and how damaging it was for the victim in this case, as well as the outstanding community service. It's really meant to be a punishment, and her voice to comply with. So we've been up to this message to read the victim's letter.
Sure. I'm sorry. Didn't know. I thought she was going to read it from Becker.
My name is Tim Ashad, and I am the victim of this case, and I realize that this latest portion of this case has gone on for a very long time, and it may seem monotonous for the court. However, it has been so much worse for myself and my 16-year-old daughter. Clearly, the goal was to frustrate the process. The state attorney cleared the judges that have sat on this case. It is fairly clear to anyone who has watched this play out that the goal was to come up with fruitless motions, false statements. Even the latest motion that was filed this past week by the defense was inaccurate. If I could see it the first time I read it, clearly the court could. But that has been the goal of the defense: wear down everyone, make up untrue statements, and attack whomever they can to try and stall the process so that everyone is tired of it. Let's remember she is here from her conviction of a false report of child abuse. As I know you are fully aware of the case, but I would be remiss if I did not review it again. This person, Delaney Loyd, went out of her way to call the abuse line and make up facts about myself and my daughter. She gave them a false name, lied about being a teacher, made up meeting my daughter, made up that she looked unhealthy, made up that she doesn't eat and that I control anything she does eat. She went on to tell the abuse line that she had no friends and was kept in her room. And of course she told the abuse number that she had been sexually abused by me. This combined with her claiming she has boxes of material in my custody case where she clearly had the court order that showed that not only was all of the allegations untrue, but made up by my ex-wife. There was no reason for her to continue to go down this path with all the information she had. And of course, the call to the abuse line was not enough. She called the soccer club I coached at, the job that I had in Colorado, and told both of them about her continued false and made-up stories that I sexually abused my daughter. She gave both of these people her website that was fraught with untrue stories. Her goal was clear: take my daughter from me, ruin my name, and attempt to have me put in jail as a convicted pedophile. Now she's in front of you to have her released from probation. She now wants you to feel bad for her because she did not violate at all. She should be allowed to go free. I am still living with the untrue statements she made. She is now having her friend from Brevard Business News continue the stories. She wants you to pretend that all of this is over and it's okay. It is not. On a weekly basis, my daughter searches her name on the web, and all the stories she put out there are still there. Only now they are from someone else, her self-claimed mentor. She will pretend she has nothing to do with this. However, anyone with clear thought can put this together and know they're doing it for her, which is actually a violation of her probation. Even when she did finally remove these articles, only when the parole officer told her to, her friends have reposted them, harassed me since she has been sentenced, and to this day continue her harassment to apparently help her embarrass me. I will not go away. Not once during this entire trial has she mentioned that she has told her friends and colleagues via her attorney, "Hey, he didn't do anything. I made it up. Stop posting anything about him." No, their goal was and is clearly to continue her original defamation of my character. I ask that you do not allow her probation to be set aside. She was deliberate, calculating, and has ruined my reputation in Brevard County, and with her continued calls during her crime, she attempted to ruin my daughter. An innocent 16-year-old girl continues to see the same things posted online. She cannot do it, but her friends are doing for her. These things, as you know, will never go away, and now we have to live with her actions forever. To let her get away with not finishing her probation is absurd. My consequences will never go away, as the items on the web never go away. Yet Dana feels her probation should go away. Why? Her original crime happened, and she was found to be guilty, and that has not changed. There has not been any change in her guilt, and the sentence was set, appealed, and denied. Why would we change it now? She should have to live up to her entire sentence. If you could imagine having someone call a place you coach at, your future employer, posting on the web, then trying to file an abuse claim about you that you sexually abused your daughter, how would you feel? She deserves more than she received, and now she wants less because she what? She didn't do anything wrong since she was let out? That is absurd. Her crime is heinous and despicable. This is disgusting that she is trying to claim she has served enough. My sentence and my 16-year-old daughter's will never go away. Be brave, set the standard. Do not worry about appeals. If it's within the law, no matter how severe, she deserves everything she gets. Remember, Dana's original goal was to ruin my life. Don't let her get away with it. She needs to serve her entire probation.
Raise your right hand, please. Swear affirm testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God. I'm sorry you found that to be funny. I didn't find it to be funny at all. One of my problems is that you have a relationship now that I just heard a minute ago, and I want to find out for sure with the Brevard Business News, who continues to apparently publish articles about this case. So what is your relationship with Brevard Business News? And you may want to ask your attorney before you answer my question.
The owner of, the male owner of Brevard Business News has been my mentor for several years.
It's a different corporation. I want the court to understand. Brevard Best News is different than Brevard Business News. Okay, I'm sorry.
Okay. I had Brevard Business News.
Right, I got that.
Okay.
But my question is, what is your relationship with the gentleman at Brevard Business News who keeps publishing, and most of them are nonsensical, they don't, unless you know the story, they make no sense. But for some reason, it's still out there.
I understand. I mean, my
There's
mugshot.
also a website, probably these folks, in Volusia County, I think, it still also has stories about it. So tell me about Brevard Business News. That's what I need to know.
Well,
Why, do you know why they keep publishing?
no,
stories
I don't.
about it?
And I can promise you, if I had any control, I would have my mugshot
But
taken
I do
down.
know from prior statements in court that there is some relationship between you and the publisher of Brevard Business News. And that's my concern today, that there is a, you know, you're laughing at the letter that the gentleman wrote.
No, I'm sorry, not at all.
Maybe a nervous laugh, I don't
Yeah,
know, but
just-
he did. And the problem I have is, this continues to be put out there in some derogatory fashion toward the sheriff and about the case. And, I mean, they throw your name in it, so that's why I'm asking if you knew anything about it.
No, if I could make a phone call and have control, like I said, the first thing I would have done, or asked to, is to have my mugshot taken off. It's not comfortable, you know, after spending over 2 years on community control, and then I'm finally able to go out with my children, and if I have my hair pulled back or a baseball cap on,
It just seems odd to me that people who are supposedly supporting you are continuing to advertise your situation. And to me, that seems like that wouldn't help you. And that's why I don't really understand. I mean, we have the one on the website that's got your picture on it, that they send stuff, apparently continuing to write stories about it. Although I don't think there was a story about your recent situation, from what I understand. But there's also the Brevard Business News, which continues to talk about your case. It just seems odd. It seems like you would want those both to go away and to have people stop talking about you and publicizing what happened. And because, as you know, the appellate court has already ruled, and that conviction is done, there's nothing to do about it. So I'm just suggesting it seems odd to me that for somebody that wants all this to go away, your supposed friends are continuing to perpetuate whatever's going on and putting it out there about you. So do you have any influence over them? You know, it seems like you would want them to stop talking about you and your case and move on. Now, as it relates to your probation, what I think is reasonable in this situation, and you can counter this if you want, or tell me what you think about it, is to place you on administrative probation so that you just have to not commit crimes, and you mail in whatever it is they want you to mail in once a month. You don't have to pay any cost of supervision, and you don't have to keep coming back in here. The only thing you really have to do is not commit any crimes, and this thing will go away. And I say that such that I believe that when you are 50% done with your probation, you had a year in jail, and then the community control was 1 year?
Yes.
it was a little over a year.
And then, well, I mean, it was ordered to be 1 year, right? What do you mean when you say it was over a year?
It was told because of the running of the VOP case.
Right, but
So they told
it
her
was
they
ordered
kept.
to be a year.
It was ordered to be a
And then
year.
the probation was supposed to be
To follow that.
3 after that, right?
Yes.
So,
Along
at
with-
what point in time will she be 1.5 years into her probation? That's my question. I'm not talking about the jail.
I understand what
I'm
you're
talking
saying. How
about
long do you
control.
want to break the
Do
probation?
we know when that will be? Because here's my thought. I think you should stay on administrative probation until you get to the 1.5 year mark of probation. Because as I read it, and I understand your interpretation of it, but as I read it, 50% of the probation is when I would say it should terminate totally. No administrative, no nothing. So that's my question. When do we get to the midpoint of probation?
So 12 years, I'm sorry, 3 years is 36 months, right?
Yes.
So April 10th of 2019 was my first day officially off of community control on probation.
So 18 months from 4/10/19 would be the halfway point. So what I would be willing to do is place you on administrative probation today, order you to commit no crimes as being your term and condition of probation. The 658.25 hours seems like enough to me, quite frankly. And then your probation would actually fully end 18 months from 4/10/19, which is 10/10/20, is that, am I doing that right? Or 9/10/20? 10/10/20? So here's what I would be willing to do today. To repeat, you're on administrative probation as of today. obligation whatsoever other than to make sure they know where you live. The probation folks need to know how to get a hold of you. So you would report to them one more time. If they ask you to send them an update on your address, if you move, you would have to do that. And then on 10/10/20, your probation would terminate completely. And there is no cost of supervision associated with this, nor is there any need past 658.25 hours. Any comment to that, or anything you want to share after that? You really ought to urge people to stop talking about you in the press.
We understand it's not beneficial to my client, it serves no purpose, and it does not help, obviously. But Judge, she did have an enormous amount of very, very, very special conditions as part of her probation. Are all of those
Not
conditions?
anymore.
Okay, thank you.
Now, I can't take away the no contact, all that stays in place. You understand that? No contact, you can't write stories about them, that kind of stuff. But as far as where you work, how you work, what you do for a living, you're fine. But as long as you're on probation, and I think I understand what you're saying now. As long as you're on probation, even though it's administrative, you can't commit any crimes, but you can't have any contact with the victim.
Well, one of the things, if I just may, because I'm not trying to look the gift horse in the mouth or upset the court, but some of them is, she can't even talk to me about the name of the alleged victim.
That's ridiculous.
She can't, I'm just,
She can talk to her attorney about anything she wants to talk to.
but
And anybody says otherwise is violating the Constitution. So you can never get a VOP out of me on that. And I'll be here until she finishes. The good Lord will. But you ought to be able to talk to your attorney about anything related to the case. That's insane. Something specific about the no contact, no writing of articles, no publishing on the internet, those would stay the same. But as far as her talking to her attorney,
No,
That's nuts.
I don't think that's accurate.
Yeah.
Anyway, I think the only thing you can do with administrative probation is make the only condition be that she not committed a crime. So I understand what your intent is, but I think it would have to be, leave her on the regular probation, remove all the conditions except for the no contact and whatever other specific things you're talking about not publishing articles about victims of the case. But technically, I think administrative probation,
so you're saying doing a mail-in probation as opposed to administrative?
and you,
It's the technical term?
I just don't think you can make the no contact a condition of mail-in or administrative probation. And that's what we're most concerned about, obviously. is-
See, I humbly disagree, because I believe I can remove the supervision part of it, which would be administrative probation. But I also believe the condition that she have no contact and offer no social media or other publication of the victim or the case as a condition of that. And if she violated, she could subject herself to a year in jail from a contempt of court standpoint. So if it was brought to my attention that you were doing this, since I'm directing you as an order of the court not to do it, I think I could jail you for a year if you did. That's my belief. But as far as the supervision of it, nobody at probation is going to have to do anything really. Your thoughts, Mr. Brooks? Aren't there some court costs that still need to be paid?
No, everything has been paid.
You show court costs still being owed? Let's double check that.
Oh, yes. Well, because
1,500 and something court costs, right?
I can't remember who told me, but I filed my 385, and I was told, just hold on to that, so that was the 385. There has been,
What's a 385?
I'm sorry, I did it. Ineffective counsel that I submitted last week.
385. Okay,
I'm
I'm
sorry.
sorry, money, not about.
So again, if I knew exactly who, I would say who, but I was advised that that stood until 2022 to have my 380.
Right, but when you ask for early termination of probation, you have to have the terms and conditions met up to that point. And so we're gonna need the $15,2250 paid pretty quickly. As long as you work out a payment plan with the clerk, nobody cares.
Okay.
So you're to say something?
Yeah, Judge, we agree. Yeah,
Let's make this perfectly clear. I need you to focus, everybody focus, because I don't want to do this 3 times. Okay? None of you don't want to do this 3 times. I'm placing you on administrative probation. What do we call it for you? I'll write it down. It's done.
No, I'm just,
She's not out of county or out of state, so it should be.
but she can,
state probation,
What?
administrative state probation?
Yes.
Okay.
So we had a conversation earlier about something that we had to fix. That's what. Okay.
she wanted to make sure that she can leave the county without consent or permission.
Right.
To go on vacation. and do
Administrative
things.
probation, which means commit no new crimes. That's your obligation. The order from the court is you shall continue to abide by those rules associated with the disclosure of the victim or non-disclosure of the victim and the victim's child in this case. If you violate, if the court becomes aware and the state proves you violated that condition, or if a citizen walks in here and seeks to point out that you violated the condition, then that's between me and you. That would be a contempt of court issue. So outside your administrative probation, you'd be violating a court order, direct court order, and that would subject you to a year in jail. Do you understand?
Yes, sir.
Do you accept that responsibility?
I get it.
All right. And you understand the consequences?
Yes, sir.
Now, the 152250, you're gonna have to work out a payment plan or continue to make payments to the clerk because you're still on administrative probation. So you should have until 10/10/20 to get that paid.
Yes, sir.
My humble opinion would be, if you pay it off by 8/10/20, nobody's gonna think twice about it. But usually when you get about 2 months out, they get squirrely downstairs and they start saying somebody needs to file some lien or something.
Okay.
So I'd get that done by 8/10/20 if I were you.
Okay.
And then on 8/10/20, your probation terminates automatically without any further court interaction. Does that
Okay.
make sense? Any
Yes, sir.
questions from anybody?
None, Your Honor.
65825 is sufficient as far as community service.
Thank you, Judge.
Thank you.
Term date is 10/10/20.
She said 8,
Oh, no, I wanted to pay, I told her to pay by 8/10/20, because I want y'all to have a couple of months to get what she's done. And then 10/10/20 is the automatic termination date, unless, of course, there's, you commit some crime and the state comes in and says you violated, which I hope for you does not happen. Anything else from anybody before we go?
Can I-
No, good what?
I just-
Tell me.
Go ahead. Ask him first.
She just wants to make sure that she can open up her own paper, unrelated to her case, it's her paper.
You can move forward in your life with any legal avocation you choose, entrepreneurial or working for somebody else. You just can't do anything publication-wise regarding your case.
We understand. I just want to make sure that she can open up her own. Thank you, Judge. Appreciate it.
Either by yourself or through another person. And that's why I was concerned about the BBN and if you might have some relationship there, because that would be enough to violate your probation if you have a relationship with them and are causing those articles to be printed. If you have any influence over that, it would seem to me it would be your best interest to get it stopped. Doesn't bother me, anything to do with our relationship and you being on administrative probation, but it just seems that you want the whole world to forget about this and you want to move on. Publishing something about it every month seems strange to me, but that's their right under that particular. And you have that right too, just not about this case.
Thank you, Your Honor.
Any questions about that?
No.
All right, I wish you well, good luck.
Thank you. Have a great day.
Evan Durbin, I have Evan.